Hello and welcome to our program, How to Get a Divorce. My name is John Ellingson. I'm an attorney, a mediator, and a collaborative practitioner. This program is presented by Collaborative Divorce Solutions of Orange County. It's a nonprofit organization. Our purpose today is to give you information on how to go through a divorce. It's not our purpose to advocate or suggest anyone go through this difficult process. There are 4 ways to go through a divorce. There's a model called do-it-yourself, there's litigation, mediation, and a newer model called collaborative practice. You know, it's easy to get married. You get a license, you say I do, and you're married. Staying married can be wonderfully exciting. It can be a difficult challenge. Occasionally, marriages break down. The divorce rate today is nearly 50%. There's 1,000 new divorce cases filed in Orange County, California alone each and every month. Our purpose is to provide you with information. We're going to provide you with the different ways that you can leave a lover. I'm accompanied today by 2 professionals. Therese Fay is an attorney in private practice in Orange. She's a trained mediator. She's a collaborative professional. John Denny is an attorney, a certified family law specialist with Minyard Morris in Newport Beach, California. He's also a mediator, and he's also trained in collaborative law. We're going to begin with the processes by asking John, tell the people watching what the do-it-yourself process is. How's it work?
Well, John, thank you. When 2 people have the simplest possible divorce, we're talking where there's few assets, maybe there's no children, and they have a good idea how they want to approach their divorce, they can do it themselves. They can go down to the courthouse, file the documents, get before a judge ultimately who will pronounce them divorced. However, a lot of times they're not sure what forms they need to fill out and how they need to do that. So there are several ways for them to get that information. The court itself, at least in Orange County, and I understand in all the counties throughout the state, has a self-help center where the parties can go and get these forms and have a clerk help them fill them out where they need help. You can also do that through private paralegal firms. You can get information in books on the internet. There are several ways for people to get the information they need so they truly can do it themselves.
And I understand the courthouse has workshops to help people with forms and some of the process.
That's right.
Now, this is a process where the husband and wife are going to sit down together and they're going to come up with their own settlement.
That's right. We're not talking about where they're going to dispute the issues. They might theoretically dispute who's going to get the children or who's going to get what asset. We're not talking about those cases. Those cases are more complex, and we'll deal with those in a minute.
So that complex case might be a litigated case. And Therese, what is a litigated case? How is it different from the do-it-yourself model?
Well, it can still be done as a do-it-yourself case. However, both parties are expected to bring their evidence to the courthouse, present it to a judge, and allow the judge to make decisions about the issues they can't resolve themselves. That could include child custody issues, how much is paid in support by one party to the other, and how their property is divided.
And do they hire lawyers in this process?
A lot of people do, some don't. I don't necessarily recommend that if you truly have to litigate your case that you do it without the help of an attorney, but some people do that and are successful.
So the attorney's role is to advise people as to the law and represent them at the courthouse.
Correct.
And those are the cases that are presented to a judge.
Yes.
So a third model we talked about is mediation. John, how does mediation work? What's involved there?
Well, John, a mediator is a neutral between the parties. As you said earlier, I do litigation, I do collaborative law, I also do mediation. When I do litigation or collaborative, I am an attorney for a party. However, oftentimes we'll get a case where 2 parties have a pretty good idea where they want to go, but maybe it's a little more complex than a do-it-yourself case, so they will seek the services of a trained mediator who can help them craft a settlement to settle all the issues. Again, we have custody issues, we have support issues, we have asset division issues. A lot of times these are more complex. The parties are fairly well agreed, but maybe they have 1 or 2 points where they're not quite sure how they're going to do it. They'll come to someone like me or you, and you will use your skills to help those people come to agreement on those points where they cannot agree or have not yet agreed.
Now, you mentioned a point, they come to someone who's a mediator like you and I. Now, you and I are lawyers, Do you act as a lawyer in this process and represent them?
Now, as a neutral, I cannot be the lawyer for him against her or for her against him. I can, and I will, when they're together in front of me, give them general legal advice. They might say, what would a court do in our case with support? How much would he pay, or how much would I pay? I can help them with those sorts of informational requests. I'm not going to advise her how she can get the better of him or vice versa, but I will help them understand the legalities, and I will also refer them to lawyers if I think they need the help of someone to make sure they understand what they're entering into.
Is part of your role to keep the playing field level, keep them focused on settlement?
Well, I want to keep the playing field level, but if it's not level to start with, if one of them, for instance, is more sophisticated in financial matters and has a better idea of where that party's finances are, or if one of them in their marital relationship acts as the bully and the other one gets bullied, I might let them know that mediation isn't the ideal format for them.
Are matters discussed in mediation public matters, like what's said down at the courthouse, or is there some sort of confidentiality?
Under the California Family Code and Evidence Code, mediation matters are confidential. What's said in my office stays in my office.
Kind of like Las Vegas.
Well, better than Las Vegas, because we have a statute that says it must stay. But the parties can feel free in that context to say things that they might not want in public, or they wouldn't say in court because a public record is made.
So how do people get information in this process? Is there formal discovery like in litigation, or are they required to provide information?
They provide information to each other. In California, we require that both sides execute a declaration of disclosure, actually twice during the process, where they disclose to the other party all of their income and assets, their expenses, such that the other party, under the law, is fully informed of all the issues in the divorce.
We've heard about the do-it-yourself model, litigation and mediation. Therese, there's a fourth model. It's collaborative practice. What is collaborative practice?
This is a process where we use a team approach. The team includes mental health professionals who act as divorce coaches and also as neutral child specialists. And then we have financial professionals who assist the parties in gathering the financial information, which is something that lawyers would tend to do in a litigated case where the parties have attorneys. And then, of course, each party would have a lawyer who advocates for them, but in a non-adversarial way, in a collaborative manner.
Okay, so we've got a team and it involves lawyers, one for each party. We have a divorce coach, financial person who's neutral, and if necessary, a child specialist. Why have this team?
Well, what people have discovered over time and come to the conclusion of is that divorce is an emotional process that happens to have legal and financial consequences. So the team provides support in all of those areas, and you are able to use people who are uniquely trained within each area rather than having your lawyers more or less step into the shoes of your therapist and your financial advisor, which is not uncommon in many family law cases.
How did this process get started?
There was a gentleman named Stu Webb who was a family law practitioner who years ago decided that he more or less wanted to figure out a way to stop the bleeding. So he started a process which has now been called collaborative law, where he brought in the mental health professionals more or less to help people separate the emotional issues from the practical decisions that they have to make.
I'm sure people have heard about how to do it, your own divorce, and a lot of people know about mediation, and litigation has been around for a long time. This process is newer. Is this process approved or accepted by the courts and by the legal community?
As a matter of fact, the California Family Code actually includes statutes that talk about collaborative practice and contain certain protections for the participants.